Hello and welcome to the channel. It's me, Chris, with a K. I hope you're all well today. There you go. I think that's going to be my new slogan from here on out. Thank you, Robbie. So today I would like to explain in this video the background of the letter that I've just sent to Companies House and what led me to send it. Now, for those who follow the channel, clearly you're going to know, but to those who are new to the channel, a while ago I sent Companies House an affidavit, a lawful statement of truth, clearly setting out my position and giving them the opportunity to respond or rebut it. But what I received back was not a rebuttal. It was a generic template style response that completely ignored the contents of my affidavit. There was no attempt to address any of the points that I made. No counter statements, no lawful challenge to what I put on record. And in commerce, an unrebutted affidavit stands as truth. So, as it stands, my affidavit remains unrebuked and therefore stands as fact. Well, hey! Now, to be fair, I didn't expect anything else because they are never going to admit on paper or over the phone how corrupt they are. So all they can do is ignore and hope that it then goes away. So I'm actually really happy with the outcome there because, like I said, my affidavit now stands as fact, much like the DVLA one that I did. And so because of this, I have written back with a statement of fact, a clear written response highlighting where their reply, failed to deal with the matters properly. Before I show you my response, I will show you their reply. So here's their reply. Dear Mr. Brooks, thank you for your email and attachment of 29th of October 2025. I have noted your analysis, but there is nothing I can add to my earlier reply. I have explained our position in this matter and it remains unchanged. The documents used for identity verification are set out in the registrar's rules, which we are entitled to impose by law. As our position in this matter has been fully explained, any further correspondence on this issue will be added to our records, but not responded to. Yours sincerely, John. So yes, like I said, it's very generic. I could have been anybody who they were responding to. So now I will show you my letter, my response, my statement of fact. And this letter will point out where they have failed to answer, where they have confirmed limitations in their position, and how their silence effectively confirms the truth of what I have already stated. It is factual, respectful, and written so when read out loud, anyone can see exactly what's been left unanswered and why that matters. So without further ado, let's have a look at this letter.
Dear Mr. Andy King, the Chief Registrar of Companies House for England and Wales. And John, thank you for your response to the fiduciary Christopher Anthony, to which you fully accept the callings and trust position. The financial commercial concerns your franchise have chosen to raise controversy against the legal fiction body corporate Mr. K. Brooks. Your office has decided to accept all the facts highlighted in the recent correspondence from the settler beneficiaries, and by not providing a point-by-point rebuttal, you have missed an opportunity to defend these issues. Thus, the parties have reached an agreement. This suggests that the matters presented to Companies House are accurate and reflect the deception, which is rather concerning. A comprehensive review of your response has been completed to ensure openness and transparency consistent with the duty of care expected under your role as trustee and debtor fiduciary. Please be advised that failure to provide financial accounting upon request for settler audit and the appropriate set-off process constitutes a breach of trustee duty and may be considered both unlawful and improper. It is recommended that you refer this matter to your financial controller. This reflects the agreed understanding regarding any remedies involving financial accounting, particularly where Companies House has not provided a true bill, supporting vouchers, or a verified complaint. This lack of engagement has not only raised eyebrows, but has also generated further speculation regarding the underlying motives of Companies House. As a result, stakeholders are now questioning whether the organisation is acting in good faith and upholding its duties with the diligence expected of a public body. It is important to note that the absence of a formal response from your office to all concerns and facts raised could be interpreted as acquiescence or tacit agreement with the position of trustee responsible to the settler beneficiary Christopher Anthony. Furthermore, the Companies House silence to offer a trustee rebuttal could impact the perceived integrity of Companies House in maintaining transparent and accountable corporate governance and make itself available to answer all concerns openly and not obfuscate and then attempt to suppress any future correspondence. One could easily think that the Companies House are deliberately hiding something, the points that are confirmed and agreed. Here are the specific points raised in the main letter that are now in agreement. Confusion on Companies House trustees' part about irrevocable trust orders. The consensus reached accepts the confusion mentioned regarding the irrevocable trust orders that the trustee is to carry out. The facts highlighted in the previous communications, therefore subject to breach of fiduciary duty by the Companies House trustees. Settler beneficiary and secured party creditor is not a person, citizen or individual. The response accepts this position absolute, the point in agreement, that the settler, beneficiary and secured party creditor is not a person, citizen or individual. Issues discussed are to settle for value, not for investigation. The response fully accepts the point that the issues discussed are meant to amicably settle for value any amount of verified complaint can assert, and affirms that the Companies House have agreed. The settler, beneficiaries' creditors' responses are for investigation, but fail to support such choosing to shut down any engagement on financial issues. Administration anonymity is paramount for public accountability of staff. The Companies House response accepts administration. Anonymity is the reason for staff not to adopt surnames for liability reasons, ensuring public accountability of Companies House franchise trustees, and staff must be adopted in government franchise. Order for disclosure of presumed adhesion contracts or minimum contacts for cognizance reasons. The response has agreed these are operated in the fictional legal world, and further Companies House is claiming under these presumption to claim cognizance inherent and subject matter jurisdiction. Identification documents created by presumption. The response asserts that all state identification documents are based on presumption, starting from birth through an illegal conversion of unalienable creator rights in the private sphere to deceptive commercial fiction contracts and obligations in the public sphere. It further claims that adhesion and minimal contracts are used as tools of deception, allowing commercial business obligations and financial instruments to be introduced. This process results in one document giving rise to another, ultimately leading to alleged deception by the UK Crown Corporation. Companies House on this occasion have decided not to make any Companies House charges in this case, as it refuses it provide a true bill and voucher. The charges are therefore abandoned by the registrar as he failed to comply with the bills of Exchange Act 1882, give there is no gold and silver, money, and in the fictional ens legis world corporations can, as agreed with Companies House, therefore only discharge debts. Furthermore, the aggressive, unhelpful John's trustee stance verbatim quote, outburst is very unhelpful. Any further correspondence on this issue will be added to our records but not responded to, is dishonourable and reflects that the Companies House have issues they wish to obfuscate. Please feel free to present a voucher and true bill for any verified services in future.
The matter is now closed on the public record for the reasons highlighted in this addendum agreement affidavit with Companies House Registrar, who chooses not to verify Companies House with Crown franchise actions, i.e. failure of Companies House to accept for value, return for value a fictional exchange of value. Please make sure that all detailed agreement and correspondence are forwarded to the Bar Guild courts in pursuant of any alleged unverified debt that the Companies House may illegally attempt. It was not my intention to cause embarrassment, but the Crown franchises should assist acknowledgeable individuals who recognise the commercial practices of the UK Crown Corporation and learn how the staff at these franchises are the real issues as they attempt to bury their heads in the sand, instead of realising the open prison walls that they are building for their own families and future generations. Give it up, the Crown modern day slavery system is now well exposed. Yours sincerely. Okay, so I just want to be clear that this has never been about confrontation. It's always been about accountability and transparency. Too often public bodies rely on template replies to avoid dealing with lawful matters directly. All I've done is hold them to their own process, to show, in writing, that they have chosen not to rebut the facts that were put before them. And that's important, because silence is an agreement in commerce. When you make a claim and it's not rebutted, it stands as truth. So that's where things stand now. Companies have responded, but not lawfully, not substantively. My affidavit stands as truth, unchallenged, unrebutted, and the statement of fact I've sent simply records that for public record. So there you have it. Let me know what you think in the comments below. Thanks for watching, and as always, stay aware, stay honourable, and stay in the private.